Dear friends, good afternoon and good evening. My name is Serghei Covali, and I'm going to be your host tonight. I welcome you to this live stream on Juridice Moldova with Dr. Rémy Gerbay. Rémy, welcome to Juridice Moldova.
Thank you, Serghei. Pleasure to be here.
The pleasure is ours. Rémy, where are you now, and what is the time for you? I know that you're across the ocean, but I would assume it's morning or lunchtime for you.
Just before lunchtime, I'm actually in Washington, or rather in the suburbs of Washington. So it's 11:30 a.m. just before lunch, the day after Thanksgiving.
Oh, after Thanksgiving. Well, thanks for being with us, even on such a day. By the way, although this stream was initially planned only for the Moldovan legal community, we understand that we may have some guests from other jurisdictions as well tuning in here with us. Everyone is welcome, and I hope you'll have a good time with us. Let me tell everyone a little bit about Dr. Gerbay. He's a partner at the U.S. law firm Molo Lamken LLP. This is a litigation boutique focused exclusively on representing clients in complex disputes. They have offices in New York, Chicago, and Washington, D.C. Dr. Gerbay holds a permanent academic appointment at the Queen Mary University of London, where he's the director of the LL.M program in arbitration. He's a former Deputy Registrar of the LCIA, which is the London Court of International Arbitration, and Dr. Gerbay is the author of leading treatises on LCIA arbitration and on arbitral institutions as well. He was appointed by the ICC Secretariat to the editorial board of the ICC Dispute Resolution Bulletin, on which he currently serves. We're here today to discuss with Rémy about his career in international arbitration, about international arbitration in general, or in perspective, as we announced, and how can young lawyers succeed in this field of law, which is sometimes thorny and complicated, I'd say. Rémy, let me just say your credentials are impressive. Now, first things first, you're a French lawyer. You graduated from a French law school, as far as I know. And I mean, how is law school in France, and what did you do immediately after law school?
Thanks, Serghei, for the very nice introduction. So you're right. I'm a French national. I grew up in France, and I started my legal studies in France at the University of Lyon, which is one of the older law schools in France. And so one of the reasons I decided to study law at the time is because for a 17-year-old French high school graduate, it was very attractive to be able to study a wide range of topics beyond the law. And in French law schools, just like in Moldova, as I understand it, when you start your studies, you cover not just legal topics, but also things like political science, a bit of economy and history of the European institutions, foreign languages, and that was very attractive to me. But very quickly, when I started to study law, I realized that I actually loved the law very much. I fell in love with the law, and in particular with public international law. That's what I thought was most interesting in law school in Lyon. And so I decided initially to specialize in public international law. I was very lucky to be able to do a master's degree, a 2-year master's in public international law in Geneva, Switzerland, not very far away from where I'm from in France, at the Graduate Institute of International Studies, which is part of the University of Geneva. And when I was there, I thought that I would practice public international law rather than arbitration. So I specialized in pure public international law, and I started to work at the UN agency in Geneva, first as an intern, and then I hustled and managed to get a first job as a consultant there. And like for many young lawyers, it was when you have a first work experience, sometimes you're a bit disappointed because there's a disconnect between what you had hoped for all these years of legal studies and what you actually see in practice. And for my case, it was that I found that working for an international organization was very bureaucratic and slow-paced. And so I found myself, at the UN as a 23 or 24-year-old young French lawyer thinking, okay, I love public international law, but I absolutely hate working in a big bureaucracy like the UN. So what can I do? And I need to change course. And of course, arbitration was the most logical field for me to go into, because it's one of the very few fields in which you can really use your public international law skills, especially if you do investor-state arbitration. And so that's how I moved into, or tried to move into, investor-state arbitration.
And how did you move? Was the move smooth for you? Did you have to move geographically?
I did have to move geographically. So bear in mind, I was a public international law specialist with a year and a half of work experience at a UN agency. So I wasn't exactly very attractive for an international law firm looking for a young associate in arbitration. I had not yet finished my, I had not done the bar exam, etc. So I really got lucky. I got a scholarship to go to America and do what you did, Serghei, which is to get an LL.M. at a US law school. And I got a Fulbright scholarship. I really caught a break there. I was really lucky. And this scholarship, which was paid in part by the US Department of State, covered all of my tuition fees in America. So I was able to go to Georgetown University Law Center, get my LL.M., take all of the courses I could find in arbitration, and take the New York bar exam and facilitate my move, my transition into private practice from an international organization. And there it wasn't that easy. I had to do what a lot of younger lawyers have to do at the beginning of their careers. And I sent about 200 or 300 CVs and ultimately got a job at Herbert Smith, an English law firm in London, which had just established a dedicated international arbitration practice. And they were keen to recruit people who had a slightly different background from other traditional English solicitors, and they wanted somebody with a civil law background, and that was possible for me to start arbitration in London after my LL.M., transitioning from public international law into private practice.
Rémy, before we delve into your London adventures, so to speak, let us just briefly talk a little bit about your experience at Georgetown University. You studied law in France, you studied law in Geneva, and then you were studying law in the US. How is this different for you, if at all? What are some of the advantages of the system, or the disadvantages of the US system, and how did this form you as a lawyer that you are today?
So first of all, I think it was an invaluable experience. I think if you have, as a young lawyer in Moldova, the possibility of doing an LL.M. at an American or an English university or Canadian university, it's a absolutely incredible opportunity. And it's one that is very costly. So if you have no scholarship, it's difficult, but it's really invaluable. The quality of education, in particular in American law schools, is absolutely without any equivalent in Europe. So for me, it was a great experience. Now, what is particularly interesting when you study law in America, as you know, Serghei, is that a lot of the courses are taught from a very practical point of view. So I remember a course, for example, starting a course where a teacher was telling us right from the first class, imagine you put yourself in the shoes of an in-house lawyer working for a German company. You have a dispute with a New York-based company, and you don't have an arbitration clause in your contract, and you don't have a choice of forum clause. You need to decide where you're going to sue the company, and the New York company's got multiple subsidiaries in different countries. Where do you go? Where do you sue? And I remember all of the European law students would raise their hands and say something to the effect of, I would look at the rules of private international law and see what jurisdiction is the most logical, blah, blah, blah. And the teacher was saying, no. Put yourself in the shoes of the in-house lawyer of the company. What do you do? And the answer that he was expecting was simply you look for where the assets are. So you look for where the money is, and then based on that, you construct some sort of argument that the local courts have got jurisdiction. And I remember sitting there in the classroom and thinking, this is not how we teach law in Europe, and I thought this is going to be a valuable, a year studying abroad. And every class was a little bit like that. It was about teaching you skills, such that law school was more like bar school, if you want, in Europe, than it was like law school, if you want. It was really about learning how to act and as a lawyer. And it was a completely different experience.
Okay. So after that, and after passing the bar, you had this opportunity to move, I would say, back to Europe, or to move to London. Is it London where you started actually to practice or work in the field of international arbitration?
Yes, very much so. And I arrived in London 15 years ago in 2005, at a time where London was exploding as an arbitration center. Up until then, the world epicenter of arbitration had always been Paris, and to a lesser extent, Geneva and Zurich. And there had always been some work in London and New York and other places, but really London was not the big center that it is today, probably the largest center by a number of cases today. And so I arrived, at a time where there was a lot of growth, a lot of cases in arbitration, and that made it very easy for me to develop a career in that field. So I started at Herbert Smith. I had to retrain as an English solicitor, so to study English law, become a proper English solicitor, which was something quite interesting for somebody from the continent like myself. After a while, I caught another break. I got very lucky. One of the partners who had founded the arbitration group at Herbert Smith told me, "Do you want to go on a client secondment? Except that instead of going to a client, we're going to send you to an arbitration institution. We're going to send you to the LCIA, the London Court of International Arbitration. And you're going to work there for a few months to help them because they need lawyers. They have a lot of work. And then you're going to come back to the firm with that knowledge of LCIA arbitration." And so I said yes. And little did I know that this would be really a game changer in my career, I think. And so I went to the LCIA for a few months, where I worked like a dog. There was a lot of work, very few lawyers, too many cases. And so we worked very hard. Went back to Herbert Smith for a few months or a year. And at the time, the financial crisis of 2008 kicked in. And that resulted in a doubling in the number of cases going to arbitration and to the LCIA in particular. So what was already a stretched team at the LCIA became completely overwhelmed by the number of cases. So the LCIA called me back and said, "Do you want to join us? Do you want to leave Herbert Smith and join us at the LCIA?" And so I negotiated, an exit with Herbert Smith. They were very kind. They let me go. And I went to the LCIA with a blessing. And I became the senior counsel of the Secretariat of the LCIA. And then because the team was growing so fast, I was very lucky. I became the Deputy Registrar of the LCIA a year later. And after a couple of years, I became the Registrar of the LCIA's Dubai office, which is called DIFC LCIA, while I was still the Deputy Registrar of the LCIA in London. So I got this great experience working for an institution. And since then, I've just been building on that.
For how long have you been working there?
I spent about 3 years and something at the LCIA, maybe 3.5 years altogether.
So you've seen and you know how a court of arbitration works from inside, I mean. Now, let me ask you a hypothetical question. Imagine that there is a court of arbitration in Moldova, in the capital in Chisinau. Population of Moldova, by the way, under 3 million. So that's not London, it's not the United Kingdom, but still. And it's a new arbitration court, and let's say that we want to develop it or to help it grow, to bring in significant or complex disputes. What would you do? How would you start? What would you do first, and how do you see that?
It's a good question. It's one that I've been asked a few times in the past because, so when I was the registrar of DIFC LCIA in Dubai, the center had just been created a few years later, before. So we had to do a lot of work to grow that center. And I've done then some more work for other arbitral institutions like the Kigali International Arbitration Center in Rwanda, which has been incredibly successful in growing from scratch, really. And so it's something that I've looked at quite a bit. And I think that conventional wisdom is that the first step is for it takes a long time for an institution to generate a steady flow of new cases that come in. And why does it take a long time? Because you need to convince the business community and government entities to put arbitration clauses in their contracts. And then you need to wait for these contracts to be entered into, and you need to wait for the contracts to give rise to disputes that can be referred to arbitration. So it's a multi-year process, right? And so in the short term, what you have to do with an organization, if you want to bring in cases and build that casework, is work on converting existing disputes into arbitrations that are referred to the center. And that means converting ad hoc arbitrations, if there are some in your jurisdiction. So you have an ad hoc arbitration, and you're going to convince local attorneys that whenever they have an ad hoc arbitration, they should agree with the other side to proceed under the rules of the arbitration institution and to transform this ad hoc arbitration into an institutional arbitration. The second thing that you do is you do that with cases that would otherwise go to the courts. So as an attorney, you have a case for a plaintiff, you're about to start your case in the courts. and you go to the other side and you ask, are you willing to agree to arbitrate this dispute instead of going to the courts? And if so, do you agree that we're going to refer that dispute to institutional arbitration at this arbitration center? And so that's the short term strategy to bring in cases. But to be able to do that, the institution itself needs to do a lot of lobbying and awareness raising and training. It needs to go out there on a monthly basis and go talk to in-house lawyers, outside counsel, etc., etc. So that's the way I would go about it in the short term. There's other steps. I'm happy to take you through other things that you can do. But so another thing that you could do, but it's in an ideal world, is do what the Bahrain Arbitration Center did in the Middle East, the BCDR. And when BCDR was set up about 10 years ago by Bahrain, the government of Bahrain, together with the American Arbitration Association, they passed a statute that provides that a certain categories of disputes have got to go to arbitration as a matter of law. So it's no longer consent-based. It's what you would call, I guess, a mandatory form of arbitration for certain types of disputes. And what that statute does is that it guarantees, right from the moment the statute is passed, that you're going to have a certain critical mass of cases going to the institution. And it helps the courts by clearing the docket of the courts. So that's in an ideal world, but if you have the possibility of convincing the authorities, the power that be in the country, to pass a statute or regulation to do that, that's great. Now, one step below that, something that might be more realistic for Moldova, is the option that they took in the new draft law on arbitration in Rwanda, which I was asked to draft a couple of years ago. And what it does is that it requires outside counsel, attorneys like you, Serghei, to advise their clients at the beginning of every case, before they can start a case in the courts. Attorneys are required to advise their clients as to whether or not arbitration and ADR in general would be suitable for their disputes. And then when you start your case, you've got to confirm to the judge that you have actually advised your clients as to whether or not ADR was suitable. And sometimes just that thing will generate a conversation with the other side, and will turn your cases into from court cases to arbitration cases, and it will clear the docket of the judges.
So there are various instruments that you can, I guess, you can fully be creative around this and try to push the idea forward. Rémy, so how did you? I know that you were teaching at Queen Mary University of London. How did you arrive at Queen Mary?
So Queen Mary is just by way of background for people who don't know, Queen Mary is one of the universities of London. It's part of the wider University of London. And a School of International Arbitration was created at Queen Mary in 1985 by Julian Liu in particular, who's a well-known English South African arbitrator. And so this is the oldest school of international arbitration in the world. And it's the first school where academics started to teach arbitration as a bona fide area of the law, like you teach, for example, contracts law or something else. And since then, many other programs were created. But Queen Mary was really the first program. It's the largest one in the world as well. And so when you're based in London, it makes a lot of sense. The center of gravity of academic life in arbitration is very much Queen Mary University. And so when I was at the LCIA, looking to transition back into private practice and academia, I approached Queen Mary and I had discussions with Julian Liu, Lucas Mistelis, and other academics, and they were kind enough to make it possible for me to join them. I did have to do a PhD, so I did have to write a PhD thesis during the first 3 years of my teaching at the university. But so it took a bit of time, but yes, it was a fairly seamless transition otherwise.
So when you say that you did a PhD, were you able to work at the same time, or you were a full-time researcher?
So there was a very short period of time, maybe 9 months, during which I was a quasi full-time researcher, because I knew I needed to really kickstart my research, and otherwise it would take too long. So I ring-fenced about 9 months of my time, during which I was not working at a firm, basically. And all I was doing was teaching at Queen Mary and writing researching my PhD thesis. but in reality, even during that time, I continued to work. So I started to sit as arbitrator at the time. I did some consultancy for other arbitral institutions, etc., etc. But I was not working in a firm. And then after that, very quickly, I went back to working in private practice for a law firm. And what I did is I basically approached the writing of my PhD thesis like you would approach, Serghei, the drafting of a memorial in an arbitration, written submission in a court case. I thought this is a writing project. There's a deadline. I need to have like interim deadlines. And I sort of did this project management chart, and I organized myself as I would have done in a case, a real life case, and I just broke it down in little pieces and just went through it, day by day, with targets, with number of words to write per day.
And would you recommend this as a path towards a career in international arbitration, or it depends?
It depends. I think it very much depends on the jurisdiction that you're in. I think for Moldova, it does make sense. Generally speaking, at the risk of oversimplifying, there are parts of the world where having a PhD in something in law, being a professor at university, is going to bring you a lot of prestige. And so it's going to make opportunities for you to be appointed as arbitrator, to be hired as counsel, to represent parties in arbitrations. And that tends to be civil law jurisdictions, in particular continental Europe, South America, the Middle East, etc. Now, in other parts of the world, in particular in the common law world, in North America in particular, being an academic is not something that is particularly valuable for in-house lawyers, for example. They think you might be too theoretical or not, practical enough. So it very much depends on the jurisdiction. But I would imagine that for Moldova, it would be definitely a way to distinguish yourself from the rest. And because it requires a lot of work, you read hundreds of articles and you really learn about arbitration when you do a PhD in arbitration.
Okay, Rémy, I mean, you have been studying and working basically in the heart of Europe in terms of international arbitration, France and the UK. But let us downsize a bit and talk to the young lawyers in Moldova, since I believe they're here in our audience. How can they succeed in the field of international arbitration? Is there a place for lawyers from a jurisdiction that is not as well known as, the well-established Western Europe jurisdictions? Do you have any advice here? We're not in Paris, we're not in Stockholm or Geneva, we're not even in Moscow. We are in a small country, maybe smaller than Rwanda. You mentioned Rwanda. I have a hard time realizing where is that on the map. I know it's in Africa, but
it's definitely. I think Moldova is probably bigger than Rwanda, although I would need to check. So I think there's two facets to the question that you're asking. I guess one aspect of it is, what can I do as a young Moldovan lawyer to learn about arbitration, get the skills to become a good arbitration lawyer? And the second aspect to it is, how can I find work, basically, and how can I do business development to generate work in arbitration? So which one? I think the second one is harder to answer than the first one, but which one do you want me to answer first?
Let's start with the first one.
Okay, the first one. So how can you get skills and knowledge about arbitration if you live in Moldova? I think that, so first of all, it's entirely doable, and that's again. But if I'm a young lawyer, what I would do is I would become a member of all of the young international arbitration groups that are around. So all of the leading arbitration institutions, whether it's the ICC, the LCIA, or the others, have created over the years groups for young arbitration practitioners. The first one was created by the LCIA in 1997, and it's called WIAG, the Young International Arbitration Group, of which I was a co-chair a number of years ago. There's the ICC GAF, that's the Young Arbitrators Forum. There's Young ICA, ICCA. I'll come back to that in a second. And these young arbitration practitioners groups are free to join typically. So there's no downside to it. You should join as many of these as possible. And by joining these organizations, you're going to receive emails with opportunities for you to learn about arbitration. There's going to be webinars. Sometimes there's going to be local conferences. If you're a very active member of these organizations, you can perhaps become a local regional representative and help the organization set up conferences at your local university or with local law firms. So you're going to have a lot of opportunities to attend conferences and learn about arbitration. Now, Young ICA is a really good one to join because they have a mentorship program. So if you join Young ICA and you become a mentee on their program, you are assigned to a very senior arbitration practitioner who's going to be a mentor, and a slightly younger person called a buddy, who's basically a senior associate in a big arbitration firm. And over a period of 2 years, they're going to be available to answer your questions about your career in arbitration. And so the Young ICA mentorship program is an incredible way of learning about arbitration. Now, in an ideal world, what you want to do is pursue some sort of a university training in arbitration. One way to do that is to take a year off and do an LL.M, Queen Mary, or Stockholm University, or the MIDS in Geneva, the Miami. There's a number of schools that teach international arbitration. They're all very good. And Young ICA actually has got a number of scholarships. So there's a couple. I think there's one for Miami. There's one for Tsinghua in China. So there's different opportunities that are available. But what is great now is that you can do distance learning programs in arbitration. So
that's what I wanted to ask. Yes.
Exactly. So Queen Mary has got a distance learning LL.M in arbitration, a distance learning postgraduate certificate, and a diploma. And they're all about arbitration. They're more or less long, depending on what you do. And you take your classes from home. You don't have to travel abroad. You don't have to stop work and take a year off. And you just do that. The LL.M is 2 years, so it's quite long. It's a lot of work, and it's something you can do around your day job, basically. So that's a good way to learn about arbitration.
So that's the theoretical part. Now, how do you get a job into this field? I know the question is rather broad, but in the end, those who want to study and move ahead, they're looking for jobs into this field.
So I think typically in jurisdictions like Moldova, you don't have any, or you don't have many practitioners who do exclusively arbitration, right? People are going to do a mix of litigation and arbitration. So if you're a young lawyer, the most logical way to start is to become a young associate in a law firm that does business disputes, in the hope that from time to time, there's going to be an arbitration and you're going to be able to get your hands dirty and work on the arbitration. Now, when you're in legal practice, you need to grow the pie. It's not just about getting a bigger share, bigger slice of the pie of the existing cases in Moldova. It's about trying to grow that pie. And so I've mentioned what an arbitration center can do to generate more arbitration work, but lawyers can do a lot of things like that as well. So it's a question of talking to your clients and saying, do you want to arbitrate this dispute or not? And so that's a good way to start. Now, you might think it's a long shot, to try to grow the pie, but the experience from other countries show very clearly that typically countries that become hubs for regional hubs for arbitration are countries where you've got a well-organized and highly motivated bar, so a group of lawyers, litigators who really want to do arbitration work, and they get together, they get organized, and they do the lobbying, they do the training, etc., and they grow the market of arbitration. That was the case of Rwanda, but there's many other jurisdictions like that. So people like you, Serghei, or others, get together, maybe create, if there's not one already, International Arbitration Association of Moldova, and through that entity, they organize training, conferences, they invite people, etc., and you get the discussion going over a period of time, and you generate these cases by convincing people to do the right thing and to use arbitration and other forms of ADR because it works.
That's something to be noted. Rémy, let's go a step backwards a bit, and under the current conditions, and we're into the COVID topic right now, COVID-19, the pandemic. Do you think is there a future for the law schools in the online realm? Is this something doable? Not just an LL.M, but maybe even the basic courses, the bachelor's.
Yeah, it's a very interesting question you ask, and it's one that we're going to continue to ask. I think COVID has forced a lot of people to stay home and to work from home. And what was just a few months ago, a year ago, very novel and daring, to do things at home, to do video conferencing, to do webinars, etc. This has become completely standard. And because it's become standard, and because now everybody's seen that it actually works, it's going to be very difficult to go back to business as usual whenever COVID goes away and we all have vaccines, etc., etc. So I think for distance learning, for example, at Queen Mary University, we've seen a huge increase in the number of students. And it's probably because this year some students are stuck at home and they might have preferred coming to London for the LL.M instead. But we have seen an increase. What I think is going to happen for the traditional courses, whether it's LL.Ms or undergraduate courses, is universities are going to become more and more flexible. In law school, we've got that principle already, where we're trying to offer the programs on a modular basis, where a student decides if he wants to do some credits, a number of classes in a face-to-face environment at the school, some of the credits online, maybe some of the credits in one of the foreign places of the school, etc. So it's becoming more and more flexible, tailor-made, and student-centered, as opposed to be university-centered. And that's not going to go away. That's going to increase. And arbitration practice, should have mentioned, that really is going to help people in jurisdictions like yours. It's now very easy to work remotely. You do not have to be physically present in the office to do work. And so that means that more and more law firms, whether it's boutique law firms like mine or large law firms, are going to want to be able to have lawyers working in less expensive jurisdictions to cut the costs and to have people, associates, etc., in places like Moldova and elsewhere, working for foreign law firms remotely, basically. I think this is really going to happen more and more.
Yeah, times are changing. I bet no one really knows, the final direction of that. But in terms of, we can assume things. We can see how things are working now. We can see that people are at home. We can see that you can do some schooling online. And from my own experience with Queen Mary, I mean, it's a great experience. I loved every single part of it. So I think it's very doable, by the way. As you said, you have to structure your time a little bit, manage it well. But if you're committed, I'm sure a good student can succeed in that. Rémy, now let's look a little bit into the practice of international arbitration. How is the practice of international arbitration now in the pandemic time? Do you have hearings online? Are counsel and arbitrators open for that? Or that's still a taboo and everyone is pushing us postponing their hearings?
I think the short answer is that, by and large, the international arbitration community has embraced change. It was really heartwarming to see. There was a very short period of time, maybe around February, March, where law firms were not too sure what to advise their clients to do with respect to upcoming hearings, whether they should postpone them or whether they should go ahead but online. So there was a short moment of hesitation, but now I think it's firmly established that you can do hearings online, that the tools are available. The community got together very quickly and produced protocols and best practices as to how to do online hearings in a COVID world. And I think now really mentalities have changed. So I think now, really, to take a practical example, before COVID, if you had one party saying, I want my hearing to be online because it's going to cost a lot of money if we have to fly all of the witnesses from Moscow and I don't know, Canada and fly them to Zurich, it's going to cost too much money. I want the hearing to be online. And if the other side said, absolutely not, I think this is, very important for me to be able to be in the same room as the witnesses, to do cross-examination. In a situation like this one, before COVID, arbitrators would have very often rejected the proposal to do the hearing online. They would have felt this is just too much, there's going to be issues with the technology, etc., etc. And now there's been so many hearings. We've heard about so many hearings from our colleagues as well, being successful, and then awards being enforced, etc. After these hearings, that there's, I think, no doubt that arbitrators will be more inclined to accept to do an oral hearing. And there will be less of a fear that if an arbitrator orders the hearing to take place online instead of a face-to-face, the arbitral award will be refused enforcement. I don't think that there is that fear anymore. I think people think that in most jurisdictions, I don't know about Moldova, but in most jurisdictions, people will judges will think, look, I'm not going to set aside an arbitral award or refuse enforcement of the award just because one party wanted it to be face-to-face and the other one wanted it to be online. At the end of the day, both parties got a fair chance to present their arguments on an online platform, so that's fine. So that's
So you're saying that, let's assume we're counsel for opposite parties, and you're saying, let's have the hearing online, and you're representing the claimant, I represent the respondent, and I say, we have to cross-examine some experts and some fact witnesses. And to me, I believe that it's a question of due process for me to be there, to see them in person, to make sure that the tribunal sees them in person, and to ask the questions that I have to ask. What would you say to that?
But I think, the questions that you have to ask, you will be able to ask them equally well on Zoom. I'm in Washington, you're in Moldova, and we're able to communicate on technical issues without any problems. So I think that would be fine. Is it really a question of due process or not? I know that this is the argument that people would make, but for me, it's not a question of due process, because there's no imbalance in terms of the party's ability to present their case. Now, some would actually argue that when a witness is facing the camera on a laptop in a Zoom session, the arbitrators and the people doing the cross-examination have got more visibility in the body language of the witness. So it actually improves the situation compared to being in a big hearing room, etc., etc. So I think it cuts both ways. But really, I think I think the consensus right now, a year into COVID almost, is that these arguments that you've raised on behalf of a respondent, etc., are going to be harder and harder to make. It's going to be really difficult to succeed on that, because we know that it works. There's been hundreds of hearings that have taken place in the past few months, and they've worked fine. There's new tools that have been designed. I mean, we're not going to be super technical here, but you can use different platforms, and they have been adapted to hearings. You have breakout rooms. You've got tools to ensure that there's no ex parte communications. There's all sorts of protocols to decide how you're going to handle witnesses. And can somebody be in the same room to make sure that nobody feeds them information? So all of that has been solved really in the past few months, little by little, with all of these arbitration practitioners that had to go through hearings like that. So, I think it's going to be hard to make that argument now.
And I guess another argument in favor of the opposition is that in terms of cross-examining either fact witnesses or the experts, if you record the hearing, which normally you would, you can actually go back and listen again and again to that witness, and as an arbitrator, and form an opinion, of his or her credibility, or the way he or her structures the arguments, and so on. So, yeah, that I guess could work as well.
You're right. I think that's an improvement, because what would happen in a traditional scenario is you would have a hearing transcript, right?
Yeah.
If the parties have got enough money, you would have an overnight transcript maybe. So it would be like live. It would be shown on laptops as you are doing the hearing. You would see the text being typed up by the stenographers. Then overnight, you would get a Word document. You could check what was said. But that doesn't really give you the same thing as a recording of the image and the sound of the witness. So if anything, online hearings might actually give you more than what you had before.
Great. Rémy, let us point a little bit the differences, or maybe similarities, between international commercial arbitration and investor state arbitration. I know that you've been practicing both. Is that doable? Can you divide yourself professionally in two directions, or they're so similar that that's not really a problem?
It's a good question. I think my perspective is that if you do investment arbitration, if you know investment arbitration, investor state arbitration, you should be able to do commercial arbitration. But if you do exclusively commercial arbitration, it's difficult to reinvent yourself as an investment arbitration lawyer overnight. And the reason to that has to do with the governing law, the law that applies, the legal principles that apply to the merits of the dispute. If you have a commercial arbitration, typically it's a domestic law. For example, the law of Moldova, contracts law, the law of New York, the law of Switzerland, or whatever. And so if you're a commercial arbitration lawyer, effectively you'll do arbitration, but the substantive law governing questions of whether there was a breach, the remedies, etc., is going to be domestic law. If you do investor-state arbitration, the legal principles will be bilateral investment treaties, customary international law. So that's pure public international law, right? And so it's different principles of treaty interpretation, very different from contract interpretation in domestic law. It's just a different law. It's like, there's as much difference between public international law and French law as there is between French law and German law, right? It's just different laws. And so that's why I think if you do exclusively commercial arbitration, there's a bit of a step up to do investor-state arbitration, because you need to learn the principles that you would not use on a daily basis. By contrast, if you do investor-state arbitration, typically you still have that a training in domestic law, right? You've become an international law expert, but you've done the domestic law before, so you should be able to do that sort of work. Now, that being said, when it comes to skills, to being a good advocate, the skills are pretty much the same, right? There's procedural differences, but really it's the same skills. It's about being good at writing, being good at oral advocacy, communications. It's all about, if you ask me, it's all about empathy and being able to read arbitrators, being able to put yourself in the shoes of arbitrators so that you can feed them the argument that is going to work with them, change your strategy when you can read from them that they're not buying your arguments, etc. So these skills are the same for commercial and investor-state arbitration.
Rémy, I know that you either edited or co-edited a mammoth commentary, I should say huge, big commentary to the ICSID Convention. How was that work for you?
Yeah, so it's a book that was published by Elgar, legal publisher, and it's a commentary of the convention, the ICSID Convention, which is the convention establishing the International Center for the Settlement of Investment Disputes. And it's a commentary where we had 101 authors, and I'm one of the co-editors. Actually, I came up with the idea of the project. And my co-editors are Julien Fouret, who's a partner at Eversheds in Paris, and an academic, and Gloria Alvarez was a Mexican academic based in Scotland. And so it took us multiple years. It took us 4 or 5 years, I think, to see through that project. We invited 100 people to contribute, and we did an article by article commentary of the ICSID key texts, and then analyzing some 400 arbitral awards. It was very, very long, but it was at the end of the day doable because we hired really, really good practitioners and arbitrators and academics. We gave them topics that we knew they would be able to write about. And over a period of a few years, we marshaled, all of these publications into a massive book, which was released earlier this year.
I'm sure it's very useful. Yeah, I'm sure it's going to be very useful for practitioners, as well as for those who want to learn about the ICSID and investor-state arbitration in general. Rémy, I know that, and you also mentioned that you practice as counsel, as a lawyer, but also you act as arbitrator in various tribunals in international arbitration. How's that for you? What's more interesting? What's more challenging and demanding?
So my personal preference is to sit as an arbitrator. I find it more exciting. But I think in order to become a good arbitrator, you need to do the work as a counsel. I think it's very hard to become a good arbitrator if you have not been in the shoes of the people that are presenting the case to you. To give you just one example, if you've been an arbitrator or an academic your whole life and you haven't done the work of an attorney, an advocate representing a party in arbitrations, you're not going to really understand the logistics of document production or the preparation of cross-examination. These things that you only do as counsel, and therefore, if you're sitting as an arbitrator, and you've got to make procedural decisions that are going to shape potentially the arbitration and the outcome of the arbitration. If you've not been in the shoes of the counsel, you're not going to be able to make decisions that will make sense from a practical point of view. You might make decisions that make sense from a legal point of view, but they may not be so. But I prefer to sit as an arbitrator, and the reason for that is because I find it really, really exciting to be sitting there, with really clever lawyers who work very hard on their cases, and they're trying to get out of you a decision that is going to be on their side. And so you've got to, not be played, by the party's counsel. You've got to try to, whenever somebody makes an application for something for interim relief or whatever, you've got to always think a few steps ahead and think, okay, so what solution am I going to give to this problem? If I give this solution, let's say there's 3 solutions that are legally correct, potentially, you've got to think what is going to happen next. If I make that decision, what is the other side going to do? And then how is the claimant going to respond to that, et cetera, et cetera. So that pressure of having to come up with decisions that work without being played by lawyers who are incredibly intelligent. It's that pressure, that adrenaline, I think, is really exciting.
Tell us what happens in the deliberation room, without making reference to any specific case, but in general, how does that work when you have a tribunal of 3 arbitrators, obviously?
I think it really varies from case to case. It depends on the personality of the arbitrators. Some co-arbitrators are not going to be involved at all. If you're the chairperson and you've got 2 co-arbitrators who are very busy, often they're going to be very happy to leave it to you as the chair to just produce a first draft. You'll have a very vague discussion of how you think the decision should land. And then you produce this first draft and you send it to the co-arbitrators and you discuss, you discuss it, but they leave a huge amount of leeway to the chair. In some other instances, you're going to have co-arbitrators that are going to want to really be involved in the case for good and bad reasons, depending on the situation. And so in those instances, you're going to have very intense discussions about the legal merits of the case, et cetera, et cetera. But that's not always the case. I think parties would be surprised to see how often co-arbitrators are just too busy and they leave it to the chair to just come up with a decision and then convince them that this is the right decision.
And I would assume that you have the experience of writing arbitral awards. And when you write an award, I'm just trying to understand how that works. Do you have a result in mind and then you build a path, or you go through the path and you see where the path takes you and then you discover the result?
So I think, we all have a slightly different approach to this. My approach is the following. And before I tell you what my approach is, the caveat is that you can't prejudge a case, right? As an arbitrator, you need to come to the case with an open mind, and you need to give both parties a complete, true opportunity to convince you that they're right. So you can't prejudge the case. At the same time, as the arbitration progresses over time, over a period of 1 year, for example, whatever, a year and a half, you're going to little by little make up your mind, right? You're not going to make up your mind at the last minute when you sign the award, and it's already drafted. That cognitive process is going to happen little by little over a period of 7 months. You receive the request for arbitration, you start to make up your mind. You receive the answer, you make up your mind differently. You have the hearing, you hear the witnesses, you look at the post-hearing brief. With everything that happens in the arbitration, you're going to go a little bit further in the path that takes you to a final decision. Now, my personal preference, if I can, is to do a lot of work before the hearing. So to really study the parties' written submissions in great detail and to start to draft the bare bones, if you want, of what the arbitral award will be. Without making my mind completely, because I know that the hearing and what's going to happen after the hearing will continue to help me make a decision. But when I get to the hearing, I think it's more efficient if you have made your mind as much as you can up to that point of the arbitration before the hearing. Because if you don't do that, you get to the hearing and you don't ask the right questions. If you just wait for after the hearing to really deliberate and make up your mind, you will have undoubtedly missed opportunities to ask the right questions, to push the parties. And that is often an issue where you find that the case is really going to turn on something that maybe the parties didn't quite address because nobody wanted to address the point. And you have to put it to them, right? So you need to have done a bit of that work before the hearing. So what I try to do is I draft, bullet points of an award with the full, procedural history, etc., the summary of the parties' arguments before the hearing. Then I go to the hearing, I keep an open mind, and then little by little, I work through that draft over a long period of time. And then when I get to the end of the process, it's really where I want it to be. So I make up my mind little by little, but I try to front load some of the analytical work before the hearing.
And if we're at the hearing moment, how much the the oral presentations of the counsel actually, at the time of the hearing, actually influence the result of the award?
I think it depends on what the case turns on. If it's a case that is going to turn on facts, for example, whether or not something happened, whether or not, at a meeting in 2015, this guy said that to that guy, etc. If there's a disputed factual element, it's totally possible that you will form up your opinion as to what really happened in that case at the hearing because of the counsel work, because of the cross-examination and the hard work they're going to put into talking to the witnesses. So when it's really a fact-heavy case, often the hearing can really play a big role. If it's really turning on question of contractual interpretation, unless normally by the time you get to the hearing, you will know what the parties' legal arguments are, right? So you should be able to make up your mind on that even before the hearing. But sometimes the hearing can change your mind on legal issues if the legal issues are very complex and you really needed somebody to summarize, if you want, things for you at the hearing to really re-emphasize what the key factors are. So I think it varies from case to case, but I think advocacy is really important in the decision-making process.
Rémy, let's switch gears a little bit, and the next question has to do with the language. Is English the language of international arbitration?
Yeah, the short answer is yes. I think the vast majority of cases statistically are arbitrated in English. And then after English, you've got French and Spanish and Russian. Arabic is used as well a bit, but the vast majority of cases, including
I lost you for a minute here.
So the vast majority of cases are arbitrated in English. Even if you have Russian parties, for example, in the vast majority of cases, it's going to be arbitrated in English. But language skills are important to understand documents, to understand exactly how, when witnesses are testifying, to make sure that translation is correct, etc. Yeah.
I know you have been involved in. I know that you have been involved in disputes and matters related to Eastern Europe, former USSR, and so, and also in disputes, that have to do with the under the jurisdiction or under the contracts of Western world, so to speak, France, England, UK, and the US. Do you see any difference between so-called Eastern disputes and Western disputes? Are they the same? Are they different? If yes, then where?
Yes, I mean, there's I think each country has its own specific sort of features that feed into the disputes. But I've done about a third of my work has been related to the former Soviet Union. A lot of London-based arbitrations relate to the former Soviet Union. And my experience is that there is a lot more formalism in legal relationships in the former Soviet Union. So a lot more attention is given to questions of whether a party was properly notified, whether the specific hoops or whatever of the process of a contract were followed by. And whereas generally speaking, in common law jurisdictions, especially in America, Canada, etc., it's a lot more about being pragmatic and practical. And yes, the rules say something, but does it really matter in practice? So there are big fundamental philosophical differences between the former Soviet Union and the Western world, and then the West and civil law and common law jurisdictions. Big differences. Also, there's big cultural differences. So in Scandinavian and Anglo-Saxon jurisdictions, Protestant sort of jurisdictions, the tolerance for illegality is very, very limited. So people are very shocked easily by, as they should, by issues of fraud and corruption, etc. So these issues become very big and central in propriety, generally speaking, for lawyers from these jurisdictions, in a way that they are less less central or determinative in other jurisdictions. In continental European jurisdictions, typically if you go to the south of Europe, and France is in between, the south and the north, so it's interesting. But if you go to the east as well and other jurisdictions, these issues are not going to play the same role. So for example, if at the risk of grossly exaggerating, but if you have an American or an English arbitrator, and you're being painted a picture of a party that is really, cutting corners and not being, very strict with the rules, etc. Typically, that plays really a lot in the image that the arbitrator will have of that party. That we think, oh, that party is not good. They're bad people. In a way that I think in some other jurisdictions, people will be whatever. They're cutting corners. That's what they do. And so you do have big cultural differences like that. But you approach your evidence as well. And that's really a thing where, you've got Africa, the rest of the world, where, if you're from America and you go to American law school, etc., you expect all companies to have a perfect record of all things. So they keep archives of documents and emails, and everything is readily available. And so arbitrators from that world struggle to understand how business is done in other jurisdictions where it's a bit more messy. Sometimes you don't have documents and people sign contracts on a small piece of paper, and there's no archive. And it's not because people are hiding the evidence. It's just that this is not how people do business. They're not organized exactly in the same way. And so you've got to be careful not to be biased as an arbitrator, not to prefer one side because they happen to be the company that's got a good archiving system,
Yeah.
So all of these things play interesting,
Rémy, let's go back a little bit to your career. So we stopped at London, but now you're practicing in the US. So you had another move at a certain point in time. Can you tell us a little bit about that?
Yes. So I qualified in New York 15 years ago. That was the first place where I qualified. But I spent the bulk of my career in London in arbitration. And my wife being American, we relocated to America a few years ago. And it was easy for me to do because I was already an attorney in the US. So it was not too difficult. But I moved to the US, and it was interesting to me because I had to rebuild a profile. I think in London, I knew everybody in arbitration. In Paris, Geneva, and Zurich, I probably know everybody in arbitration. And in London, I knew, in New York and DC, I knew people, but perhaps not quite as many people. So I had to rebuild, a career there and a network and change the cases that I do. And that was really a good thing. But for me, where it's been an invaluable move is that I've now worked with US litigators. So I've done arbitrations with my partners, my colleagues who are litigators, who do US litigation before the US courts. And I've learned so much in the past 3-4 years working with them on cases, seeing how they prepare. To give you an example, and you know that, Serghei, but to give you an example, in my firm, we're a boutique firm, 40 lawyers, 3 offices, Chicago, New York, and DC. In each office, we have a moot court room. So in each of our offices, we have a large meeting room that is set up like a court with a place for the judges to sit and the witnesses, etc. And we use that to prepare cases. And that's something that in Europe people don't really do. It's over the top, if you want. But that level of intense preparation is something that the American litigators just do as a matter of course. And so for me, it's been a fantastic experience to really relearn my job with US litigators.
What do you think of mooting arbitration cases before you go to in front of the tribunal?
I think it's great. It's a great idea, and that's the approach that now I take. You've got to be prepared for the hearing, and
does this have a toll? Sorry, does this have a toll on costs?
Yes. So, well, it depends on what your fee arrangements are, but you're right that if you are applying hourly rates, then you're going to have 2 hearings. The mock hearing and the real hearing. It's going to be very costly. But of course, if you have flat fees or results-based fee arrangements, it doesn't move the needle too much. But at the same time, you've got to see if the firm has got some skin in the game. So if the firm, which is increasingly the case in arbitration, has got a success fee so that they get more money if they win the arbitration, they will want to mock the case. They will want to do a moot of the hearing because they will want to be as prepared as they can be to win the case.
Well, Rémy, it's been a little bit over an hour in our discussion. Time flies, I guess, when you're having fun. Let me just wrap up a little bit, maybe with kind of like a general ending question, if you're okay. In the end, Rémy, for young practitioners, what are the 2 or 3 most important skills that a young lawyer should have to thrive in the field of international arbitration, be it commercial or investor state or?
So I think you need to be a good lawyer to start with. So you need to have good legal analytical skills. You can't just not have these skills. You need to be able to do the bread and butter of the work, which is legal analysis. You need to be a good lawyer. You need to have good, I think, understanding of private international conflict of law, because in arbitration, often you're going to have different laws governing different aspects of the arbitration. A law governing the merits will be different from the law governing jurisdiction, maybe, or the procedure. So you need to have that sort of mental flexibility to maybe have studied private international law, but otherwise it's difficult. I think you need to write well in English. So you need to work on their English language skills, and it takes a lot of time. But you need to write well. But ultimately, I think if there's 2 qualities that you need to have to succeed in arbitration. I've mentioned one before. It's the first one is empathy, and the second one is flexibility. So empathy means really the capacity to put yourself in the shoes of other people. And that means the capacity to put yourself in the shoes of the arbitrators so that you can feed them information that they need and want, you can change your arguments based on how they react. Empathy in the sense putting yourself in the shoes of the other side, so you can predict what they're going to do. You can understand why the other side, said something at a certain stage of the facts of the case, what was going on in the company, what were the pressures, what were the motives for doing this and that. So all of that requires really being able to get out of your shoes and putting yourself in the shoes of somebody else. And then in addition to that, so there's flexibility. You need to be able to work in a world that is a bit chaotic, because frankly, arbitration procedure is chaotic. When you litigate in the courts of Moldova, I'm sure, and other countries, you have strict rules of civil procedure. You know what is going to happen. There are things you can do, things you cannot do, and it's sort of scripted in a sense. In arbitration, it's often, for outsiders, it looks like a hot mess. You can't tell in advance exactly how an arbitrator is going to decide on procedure on the merits. And so you need to go along with the flow if you want. You can't expect things to be very scripted, and you need to just go with that. And so it attracts arbitration. Maybe as a final thought, it attracts a certain kind of people. I think it attracts people who are interested in adventure. It attracts, it's an area of legal practice for the adventurers, of us, people who want to go out of the beaten path and do things, differently.
Thank you, Rémy. Very useful advice and extremely interesting discussion. Well, yes. Thank you very much, Rémy, again. I wish you good luck, and I hope to see you again in a context like the one today. For everyone else, ladies and gentlemen, thank you for tuning in with us. I hope you found our discussion useful and interesting, the same way as I did. This was Juridice Moldova with Arbitration in Perspective. Have a very nice evening. Bye-bye.